Our last case today is People versus Jaber. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of that 15 minutes if we do not use it up, and even if we do, we might bring you back up and talk to you for another 15 minutes.
Or more.
Please, we'd ask that you keep track of your own time, and you have 2 minutes of a free fire zone. And begin when you're ready.
May it please this honorable court, Alona Sharon appearing on behalf of the defendant appellant Rami Jaber. I understand that I'm responsible for tracking my own time. I will share 3 minutes of my time with Ms. McCann with the hope and intent that she will address the appellate review of departure sentences should you need to address that issue. I will attempt to reserve 2 minutes of time for rebuttal. We are here today because the sentencing judge in Mr. Jaber's case refused to follow the rules. The trial court relied on erroneous fact-finding to depart upward and impose an unreasonable and disproportionate sentence in violation of due process. The trial court assessed 15 points for OV5, despite the fact that it admitted on the record that statements from Mr. Roberts' family members were insufficient to support scoring of the offense variable. The trial court imposed a harsher sentence because Mr. Jaber refused to admit his guilt in violation of Yenir. The trial court, in violation of this court's decision in Beck, imposed a harsher sentence because it disagreed with the jury's verdict and believed that Mr. Jaber's actions were premeditated. And finally, the trial court imposed a disproportionate sentence that it failed to justify and that was based on the litany of errors I've just detailed. For any of these reasons, Mr. Jaber is entitled to resentencing. And depending on which grounds this court remands for resentencing and whether it remands to a different judge will dictate whether a court should address other claims as well. I understand that this court is not an error-correcting court, but this case is broader than simple error correction. This case gives this honorable court an opportunity to clarify its holding in Beck, to provide direction to trial courts regarding the proper consideration at sentencing of a defendant's refusal to admit guilt or his lack of remorse, and to clarify to sentencing courts the type of psychological harm that must be demonstrated to support a scoring of OV5. The trial court improperly assessed 15 points for OV5, and quite frankly, I think the trial court acknowledged that the record was lacking. If you look at the transcript of the sentencing at page 15, the trial court, and this is a quote, said, "The court is going to, notwithstanding the fact that the two gentlemen that stood here and the statements that they made, the court is going to assess points for OV5. This has to be psychologically damaging for this family, and I can see the tears and the trauma that this has caused without anyone even having to speak. So the court is going to score OV5. This makes Mr. Jaber's case incredibly similar to People versus Bailey, which is cited in the brief. Right? Every murder is going to cause grief for family members, but serious psychological harm is something more than just grief, and I don't mean that in a callous way. But if you look at the statements made by the surviving wife in People versus Bailey, you have almost very similar statements to what was made in Mr. Jaber's case, and also People versus White. This court's decision in People versus White, a 2017 case, which, although it's an OV4 case, this court has previously recognized the language between the two OVs are identical. The standard is the same. The court simply can't assume that a family member or that a certain type of psychological injury comes along with a certain crime or being a victim of a certain crime. So all of those facts taken together, the scoring of OV5, given the record that was before the trial court, was erroneous. And Mr. Jaber is entitled to resentencing on that error alone because it would affect his properly calculated guideline range. As it relates to the Beck error, it's unquestionable right from the record that the trial court judge disagreed with the verdict. She was very clear about that. I think the parties very much disagree about how to interpret the court's statements at sentencing regarding her disagreement as to the verdict. And it starts at page 23 of the sentencing, where the court says, "I don't agree with the verdict." She comments that Mr. Jaber had time to reflect on his actions and that he had time to formulate how he would proceed. And her statements continue on page 23 and on to page 24. And what I would argue to this court is that she then goes on to give a list of reasons why she's going to upward depart, but those same reasons are her explanation as to why she believes Mr. Jaber's actions were premeditated. "You interjected yourself into an argument and asked Mr. Roberts to stick around," which, aside from the fact that it's factually incorrect, this is a reason, right, that she believes his acts are premeditated. "You came from a place of safety and invited Mr. Roberts behind bulletproof glass twice. You sprayed Mr. Roberts in the face, and then you shot him." And then she provides commentary that his actions were egregious and avoidable, right? All of these are the trial court's reasons as to why she believes Mr. Jaber's actions are premeditated. I think that's why this record is very clear that the trial court committed a Beck violation. Whereas the prosecution would like to look at the trial court statements sort of in two separate boxes, I think when you look at the trial court statements and read through them, it's very clear that this is the court's explanation about why his actions are premeditated, and it's very clear that this is a Beck violation. I next want to turn to Mr. Jaber's alleged failure to admit guilt and this court's decision or order in Yenir. So I think it's important that in Yenir, right, this court reversed the Court of Appeals decision that found that the trial court made no error at the defendant's sentencing. And at that defendant's sentencing, the trial court didn't invite any statements from the defendant at his sentencing, didn't try and get the defendant to admit guilt or make statements regarding his remorse. The trial court simply expressed that it was, and this is a quote, "difficult for the court to relate to one in your position. You deny that you committed the crime of which you've been convicted. The court doesn't hold that against you," and goes on to make a couple additional statements. But this court reversed and remanded for resentencing, finding that you couldn't penalize a defendant for refusing to admit guilt. And when you look at those statements and compare them to what happened in this case, you have a trial judge, the defendant made no statements in the PSI and none at sentencing. He passed on the opportunity to allocute. But then the judge takes issue with the fact that Mr. Jaber, when he testified, when he was asked if there was something he could have done differently, he wished that he wouldn't have gone to work that day. And so this is almost more troubling than punishing a defendant who doesn't make statements that the court likes at sentencing, because these are statements that Mr. Jaber made while testifying, right? Well,
Would it be different if he had made those same statements at sentencing? I mean, is the problem here in this case is that the judge was relying on statements made at trial, and those statements were critical to his defense, right? They would have been completely inconsistent with his defense of self-defense.
Right.
But say that's not the case, he's convicted, right? This metaphysical discussion that has been between evidence of guilt or remorse, say he says the same thing at sentencing, I would have not been there that day, or I wish I had not been there that day. Is that okay, or is it never okay to rely on that?
Well, first of all, I don't think, respectfully, Justice Kavanaugh, I don't think those statements indicate a lack of remorse. And I think the case law is clear that because he has an appeal of right, he can continue to assert his innocence, and that cannot be held against him. I think the case law is clear on that. But what is so problematic here is that these statements were made during trial, and they were made in the process of a defendant asserting right, a complete affirmative defense to his actions, which I've made the point in my brief is really troubling how the Court of Appeals kind of got around this issue. But I think that this court, you know, this test from Wesley is, it's not a binding decision, it's not a majority decision, and so many recent decisions from this court and the Court of Appeals stick with the principle from Yenir and other cases that you cannot penalize a defendant for refusing to admit guilt or for refusing to admit guilt. But I also think that this court should take an opportunity to perhaps clarify and recognize that a refusal to admit guilt and a lack of remorse, the distinction is nearly impossible to make. And for a judge to try and differentiate between those two and then use it to justify a harsher sentence, I think direction from this court is necessary. I will jump forward to the erroneous fact finding just very quickly because I do think it's detailed pretty thoroughly in the brief. There is zero support in the record that Mr. Jaber ever reviewed surveillance video before calling the police, and the prosecution offers you none. Second, there is no support in the record that Mr. Jaber asked Mr. Roberts to stay in the store to further this interaction. I have provided the court with timestamps. He asked him 4 different times to leave his store and to let him take care of his customers. That fact finding by the trial court is incorrect. There were 5 reasons given for an upward departure, the majority of which are factually incorrect. That violates Mr. Jaber's due process. And the remaining reasons either violate Beck or Yenir. And for all of these reasons, Mr. Jaber is entitled to a resentencing, and I will welcome Ms. McCann up to the podium.
Good afternoon, Your Honors. Jacqueline McCann. I'm here for CDAM today. And in the brief, in CDAM's brief, we talk about the amendment to the statute in 2021. But I didn't want to leave the court with the impression that Mr. Jaber, who was offense date is obviously before that and was sentenced before that, somehow would not be able to prevail on a proportionality analysis under Steenhouse should you find that there were no errors in OV5 or Beck or Yenir. Under Steenhouse, at pages 473 through 476, this court sets out the current standard. And the extent of the departure does, the reason for the extent of the departure does have to be articulated by the trial court. And the appellate court's review does hold that it's an important consideration, the extent of the departure. It's not that those things aren't looked at under Steenhouse. It's just that when Steenhouse was comparing our test of proportionality to Gall and the federal standard, this court said that we're going to walk a little bit back from Milborn and say that it can't rise to the level such that it would be the equivalent of saying the court had to give a substantial and compelling reason, or that there's some sort of mathematical formula that the court has to take into account when articulating the extent of the departure or on appellate review. But in the future, and so we've had this discussion with the court in the past, Dixon Bay was the companion case to Beck, and this court ended up denying leave in Dixon Bay, but this same topic came up. For upward departures, the rule that this court established, or the remedy, I should say, that this court established in Lockridge was not constitutionally required. And then in 2021, the legislature amended the statute. So going forward, whatever walkback this court made in Steenhouse to Milborn, this court will have to reevaluate in light of the amended statute and our position that the legislature has reinvigorated the slight walkback that this court made in Steenhouse. And if the court doesn't have questions of me, I will save Ms. Sharon's time.
Thank you.
Good afternoon. I remain Tim Boffman, and representing Tim Worthy, the Wayne County
Busy
prosecutor. In Booker, the United States Supreme Court held that the federal sentencing guidelines were unconstitutional because they included the scoring of variables based on judicial fact-finding of facts that had not been determined necessarily by the jury verdict, and because they were mandatory. And the remedy was to make them advisory. Judicial fact-finding still was permitted, but the guidelines were made advisory. But why were they mandatory? The judges didn't have to sentence within the guidelines in the statutory scheme in Booker. And the court even said in Booker, at first glance, one might think, well, if there's only a limitation by the statutory maximum, what's the problem? And the court said the reason there's a problem is because actually, though you can depart, you really can't depart in very many cases, because the guidelines take into account all the relevant factors one can think of, and you can't depart for a reason under the statutory scheme. You can't depart for a reason that's included within the guidelines. And if you do depart, the extent of the departure is viewed for whether or not it's reasonable. So since it's reviewed for reasonableness, and since you can't depart for a reason that's already covered by the guidelines, the guidelines are really mandatory. And in Lockridge, this court dealt with a similar scheme, but the departures had to be justified by substantial compelling reasons rather than reasonable. And the court determined that following Booker, the Michigan scheme was going to be also advisory rather than mandatory, and that an out-of-guideline sentence would be reviewed, as Booker did in the federal system. The out-of-guideline sentence would be reviewed for reasonableness, but it's, as in the federal system, the sentence is reviewed for reasonableness. It's not the extent of the departure. That was a problem that the court saw, the United States Supreme Court saw in the sentencing scheme in Booker, that you review the extent of the departure rather than the sentence. And federal cases since then have made clear it's a, whatever you want to call the sentence the judge gives, it's a unitary sentence, and the sentence is reviewed for substantive reasonableness. So in Michigan, and the United States Supreme Court has made clear that in reviewing an out-of-guideline sentence, as to quote from the court, the reviewing court may not apply a heightened standard of review or a presumption of unreasonableness to sentence outside the guideline range, although, and I agree with my colleague here, the judge in determining whether the sentence imposed, not the degree of the departure, but whether the sentence imposed is reasonable, in Michigan under abuse of discretion guided by the principle of proportionality, it can take into account the fact that there's a departure and what it is, but you're still not determining is the departure reasonable, you're determining is the sentence reasonable, understanding that here is what the out-of-guideline sentence is, here's what the guidelines themselves were. And the federal system made clear that in order to make the guidelines advisory, that advisory means advisory, and that a judge is free to score the guidelines consistent with the statute, as it must, and then to say, for policy reasons, I disagree with where that comes out, and I am going to give an out-of-guideline sentence because as a matter of policy, I think that's wrong. Or here's where the guidelines come out, and they come out because I score X factor at 10, and I think that's wrong. And as a matter of policy, because this is advisory, I've been advised and I'm disagreeing. And the federal court said, yeah, you have to allow that or the guidelines become mandatory. The statutory amendment was mentioned. This case is before the statutory amendment, so it's really not under that, but I would mention that it doesn't really remedy anything. It changed, I think it was, the legislature acted to address Lockridge. It begins by saying the judge may sentence within the guidelines rather than shall, but then goes on to say you can't depart for reasons that are covered within the guidelines unless you find in this case that they weren't given appropriate weight or were given too much weight. And they don't say as this court said in Steenhouse, that the sentence is reviewed for reasonableness. They say the extent of the departure is reviewed for reasonableness. So we kind of have the Booker scheme reenacted in the statute. So the problem that occurs that I would like to see, part of the reason I'm here, aside from defending the judgment here, is to have the court address, is that in Steenhouse, the court made very clear that we don't have the presumption problem that the court said can't occur, because we don't review out-of-guideline sentences that way. the court said, we don't impermissibly measure proportionality by reference to deviations from the guidelines. The key test is whether the sentence is proportionate to the seriousness of the matter, not whether it departs from or adheres to the guidelines range. So Steenhouse said that's the way we do reasonableness review, abuse of discretion in Michigan. We don't view it by whether it departs or adheres to the guidelines. It's not measured by that, although that's a factor that can be taken into account. The problem is that's not how the Court of Appeals is doing it. There are hundreds of Court of Appeals cases that say that an out-of-guideline sentence is only reasonable if it's more proportionate than a guideline sentence. And if that's not a presumption that an out-of-guideline sentence is disproportionate, then I'm not sure what it is. It's not a holistic look at, is the sentence that was imposed above or below the guidelines an abuse of discretion, looking at reasonableness, guided by the principle of proportionality. It's saying you may have a proportionate sentence, but if it's not more proportionate than a guideline sentence, then it's defective. And they also remand routinely to say the judge gave an inadequate statement of reasons justifying the departure, rather than saying, which would be appropriate in some cases, that the court did not give an adequate statement of reasons justifying why this sentence that is out of the guidelines under Steenhouse, justifying why it is proportionate. So I would hope the court would inform the Court of Appeals, which cites the Smith case, which is a pre-Lockridge case. Pre-Lockridge, substantial compelling review applied, and this court said under that scheme, you have to justify why a sentence outside the guidelines is more proportionate than a sentence within the guidelines. Then Lockridge came. That's not the test anymore, and the Court of Appeals applies that test on a routine basis. So,
Do you think that part of the reason maybe why the Court of Appeals does that is because the statute, like, they're only reviewing sentences that are above the guidelines because the statute says they don't get to review within guideline statute? Or within guideline sentencing, and so if we're throwing all sentencing in to review for proportionality, then this above, beyond, outside, departure.
I think they're doing it because they look at Smith, because they routinely cite Smith, and that was the standard before Lockridge. If a sentence is an outside the guideline sentence, then we look if there's substantial compelling reasons, and the sentence has to be justified as more proportionate than one within the guidelines, and they just continue to parrot that as the test, and it's just not the test. And in this case, then, the issue would be whether or not this court believes applying an abuse of discretion standard was the sentence given by the judge outside the range of principled outcomes when you review for whether it was reasonable, guided by the principle of proportionality. Now, the defendant says, well, but the judge considered lack of remorse, and you can't do that. Two things. One, this is not a lack of remorse case. If you look at all the cases concerning lack of remorse, including Wesley, they all say there are three factors: the defendant's maintenance of innocence after conviction, the judge's attempt to get the defendant to admit guilt, and the appearance that had the defendant done so affirmatively admitted guilt, his sentence would have been less severe. Right at the first factor, the defendant's maintenance of innocence after conviction. That's not what happened here. This is not a lack of remorse case under those cases. And if it was, I spent a fair amount of time, though I don't think this is an appropriate case for it, but in an appropriate case, I would urge the court to follow the concurring opinion in Wesley of Justice Michael Kavanaugh, joined by Justice Boyle, where he said, while the defendant is certainly free to continue to assert innocence, a sentencing judge should not be required to tiptoe through the metaphysical distinctions required to separate that continued assertion from a lack of remorse, and should just be able to consider that. But that's not what happened here. The judge considered something the defendant said on the stand testifying, and that just has nothing to do with any of the lack of remorse
But
cases.
he asserted self-defense, so how do you hold
How
that
could he
against?
walk
Well,
that back if?
You're asking a different question, and whatever that is, it's not governed by the lack of remorse cases. Can the judge take into account defendant's testimony, and what did it mean? He could have said, I shouldn't have come out from behind the glass. And the victim would be alive. I wish I hadn't come out from behind the glass, because he did. And I believe his attorney was leading him into showing some empathy for the victim, and it didn't happen. He didn't get the answer that he thought the defendant was going to give. Instead, he expressed concern for himself rather than concern that this person was dead.
Is that really a distinction? I wish I didn't come from behind the glass, and I wish I never went there that day. I mean,
Well, yeah, I think it's a distinction, and that's just off the top of my head example. He could have said something else. I wish I would had a better view. I wish I hadn't have thought that he had a gun when, if you watch the video, you can see why the jury rejected his self-defense claim.
I wish that I hadn't gone in today, or wish I'd stayed home today, kind of just sum all of that up into one.
But whatever weight you wish to say that the judge could have given that, it has nothing to do with the lack of remorse. It's not a constitutional issue. The judge considered that the defendant had the opportunity on the stand to express some concern for the fact that he'd taken a life, whether in self-defense or not, and he didn't do that. And the judge considered that a lack of remorse, and that consideration, even if it shows a lack of remorse, has nothing to do, is not inappropriate
But
under
isn't
any...
the lack of remorse supposed to be tied to rehabilitation too? How was it tied to that here?
I'm sorry, I didn't...
Tied to like the ability to be rehabilitated? Isn't that supposed to be like one of that's supposed to be the connecting factor with lack of remorse? Was that tied together here?
Well, the judge doesn't have to find lack of rehabilitation to find that this sentence in this case under these circumstances is the appropriate proportionate sentence. I mean, that's not something the judge has to say. I am finding that you can't be rehabilitated. That's why I'm going outside the guidelines.
Okay, if we could I turn to OV5 for a moment?
Oh, sure, sure.
I know we haven't, there's a lot of moving parts in this case, I know, and everybody's having to move through them very quickly. So I'm wondering, I mean, the trial court here, I think, if I have this right, said notwithstanding the statements of the brothers, she was going to go ahead and assess the points under OV5. She seemed to be acknowledging they didn't have enough to score it, but she scored it anyway.
Well, I think she was acknowledging that they hadn't sought treatment. I mean, I think the question was asked, and I can't swear to it. Had they sought treatment, they hadn't sought treatment, notwithstanding the fact that they hadn't. And the statute specifically says, in making the determination, the fact that treatment has not been sought is not conclusive. So it was like, notwithstanding that you're not seeking treatment, what you said, you know, the father's son, the mother's son was killed on Mother's Day, which was also the birthday of the brother, and that was sufficient under the statute to say that there was that kind of harm, even though treatment hadn't been sought. The judge believed that, as the brother said, every Mother's Day, this is going to be a problem for us.
So should OV5 get scored in every one of these cases?
No.
What
I mean,
about this case distinguishes it from every other tragic case?
I think what distinguished it in a large part was that the victim was killed on Mother's Day and the birthday of his brother, which would cause them more psychological harm than the ordinary case, because, as the brother said, every Mother's Day, this is what we're going to be reliving.
Is that
As opposed to-
psychological harm or
someone hates
emotional
their
harm?
birthday, right? I mean, isn't that, I mean, we're not picking days, right? I mean, all of this is tragic, but, I guess, I don't know, why is it the birthday or Mother's Day make
Well,
it not just
I guess all I
psychological
can
harm, but serious psychological harm for which treatment would be warranted?
Well, and also we have to take into account, I think, that the mother who was scheduled to speak, and the defense argues that it's a fact not of record when the judge says, I understand you're unable to speak. Well, she's sitting in the back, she's listed as a person to speak, and she's sitting in the back of the courtroom sobbing and doesn't come forward. I think the judge can fairly conclude that she was unable to speak. So you have her sobbing in the courtroom, not speaking, and I think it is a factor one can consider that on a day of particular significance and joy to two of the surviving relatives, this is what they're instead going to have.
But counsel, the challenge for the court is it's hard because we don't have a determining factor that we can use to structuralize it, right? So we have a situation where you don't have direct evidence. You have a day of the week, you have specific holidays, things of that sort. You have non-testimony, but you don't have anything kind of specific, structured, focused that we could use as standard.
No, I think that's true, and I think if you look at the cases, that's true, unless the court, wishes to hold that though the statute says that treatment hasn't been sought is not conclusive, that in fact treatment either has to be ongoing or has to have been sought, because that gives you something to point to and be structured. Unless the court's prepared to say that, then you're going to have to look to what you might refer to as unstructured evidence, because there's not a lot else other than actually seeking treatment or actually undergoing treatment, and those under the statute seem not to be required. My time is up. Thank you very much.
Thank you. Do I have about a minute left?
Just very briefly in rebuttal, regarding some statements from the sentencing record and OV5, I would very strenuously object to any suggestion to this court that there were statements on the record at sentencing that his mother wanted to speak but couldn't. That is absolutely nowhere in the record, nowhere in the transcript. That is an assumption to a certain extent that was made by the court, but there is nowhere in the transcript that the court was informed that the mother wanted to speak but was unable to do so. It is simply nowhere. Secondly, I would just like to say that under no record, under no rule could this sentence be proportionate for Mr. Jaber. He came into this case with no criminal record but for a littering ticket, but his sentence is one that could only be imposed for somebody with a habitual fourth enhancement, if you look at the grid for this offense. His sentence was 150 months, or 12 and a half years, if my math is correct.
Counsel, can you respond to Justice Welch's question, which is, if this standard were to remain, you could basically score OV5 in literally every case, right?
Yes, and that is, I think, one of the arguments I hope to make, but there's only so much I can talk about,
Sure.
right? And only so fast I can go. But yes, and I think that if that was the standard, if that was to be the rule, then that's how the legislature would have drafted it, right? That in every homicide case, OV5 should be scored, but that's not what it is. The standard is something higher, a serious psychological harm, and on this record, the evidence of such serious psychological harm is lacking, and scoring of the offense variable was erroneous.
Thank you.
Thank you.
Case will be submitted and the court will stand adjourned.